India is wedded to the concept of welfare state, philosophy of welfare state, having adopted rule of law which is running like a golden thread through every article of Indian Constitution, and it provides that all the individuals, whether even those who would have still to come in this world, they people will have also to enjoy equal opportunities. Because I would like to point out here that application of law starts even prior to the birth of a child, and it remains in operation even after the death of a person. So, the paper highlights that no person can enjoy absolute rights in a democracy, in a civilized society, in as much the system is based upon the philosophy of equal treatment for the present generation, equal treatment for the future generation, equality of opportunity and status. So, presently, in the words of Justice R.C. Lahoti, in the case of Intellectual Forum Tirupati versus State of Andhra Pradesh, His Lordship held, the world has reached a level of growth in 21st century as never before envisaged. While the crisis of economic growth is still going on, the key question which often arises and the courts are asked to adjudicate upon is whether economic growth can supersede the concern for environmental protection, or whether sustainable development, which can be achieved only by way of protecting the environment and conserving the natural resources for the benefit of humanity and the future generations, could be ignored in the gap of economic growth and compelling human necessities. It is clear before all of us that healthy and clean environment is a prerequisite for our own existence as well as for the existence of this planet Earth. And accordingly, Article 21 of Indian Constitution, in pursuance of the dream enshrined in the preamble to the Constitution of India, dignity of life, it assures right to life and personal liberty. And if we look at the other angle, look at the problem from other angle, the problem of pollution has drawn the attention of entire world, and the governments of all the nations are trying to protect and enhance the quality of environment. Regarding the hazardous result of environment pollution, recently International Scientist Association has warned the mankind that half of the creatures living on this earth will have no longer existence till 2050. So, in fact, it has become indispensable need of the hour to deal with the problem. And now I am coming to the topic of environment protection under Indian legal and constitutional framework, how it has been dealt with. As law is regulator of human conduct, I used to take it, it regulates the activities, what the law is. In fact, it is a collection of rules which regulate every aspect of our life. Every aspect. It may be religious, it may be philosophical, it may be political, it may be economical. It is the regulator of human conduct. And a plethora of legislations has been passed by the legislature in India after 1850 onwards. And the other two organs of the government are also trying to tackle the problem of environmental pollution, due to which the survival of the mankind is at stake. So social investigation in the matter of pollution reveals that the main reasons of problem are population growth, deforestation, which are usually counted. But what I feel, the qualitative research methodology leads us to conclude that the ultimate reason of environmental pollution is the materialistic and unnatural urge of development at any cost. So the level of pollution in all the spheres of life is at alarming rate, and even a glut of legislative steps has been taken. And it appears in India, in Indian scenario, that there is not the lack of law. In fact, lack of implementation of law is there. And the problem is continuously posing a threat to the humanity on the earth and getting its strength from the passive participation of not of the political leaders or bureaucrats, but of passive participation of the citizens. Lack of will on the part of thereafter lack of will on the part of bureaucrats and politicians. And regarding the concept of social engineering, The fundamental dictate of human psychology and law of nature is that man is governed by the theory of pleasure and pain. The ultimate interest of human life is the pursuit of happiness. The man runs throughout his life in pursuance of his ultimate goal. And as Thomas Hobbes also stated that in a state of nature, he supports equality. In a state of nature, everyone is entitled to everything. So look at the interest of coming generations, future generations. They are also entitled to everything which we have. So, but this idea now in present era leads to friction, because in today's world, man's life in a state of nature similar is that of as one of the fear and selfishness. If one looks at the gravity of the problem, no doubt the society is moving again through the modern phase of state of nature. The few individuals claim enjoyment of natural and duly recognized rights, and other claim, like us, equally competing rights. So it amounts to denial of rule of law as postulated in the year of 1959 by the International Commission of Jurists that also sit in Delhi, and that is also known as Delhi Declaration 1959. It postulated, it put all the organs of the government under an obligation to provide a dignified atmosphere. So if we look at the problem from that angle, it amounts to denial of dignified life. So therefore, in this scenario, the appraisal of social engineering in Indian context become more important and indispensable, as this subject matter involves right to life and its enjoyment, which is the fundamental of all the fundamental rights. So I have just made an attempt to make an analysis of the outcome of the adherence to the process of social engineering by the Honorable Supreme Court. The appraisal would be effective enough to enlighten the common man with the view of sensitive judiciary as a savior of their basic rights in the real sense. So this concept implies the social factors are to be kept into consideration not at the time of making of law, but these are to be kept into consideration at the time of application and interpretation of law. So these social factors include social effects of laws in existence, mechanism to apply laws, lacunas in laws in existence, a constant study of the critical aspects like implementation, psychological, philosophical and judicial method to apply law. So friends, the main theme of this paper is how the Supreme Court in the past has tried to strike the balance among the conflicted interest. Just take the example, right to life. All we know, I am skipping on the point that right to environment protection, clean and healthy environment is the fundamental postulate of right to life. I am coming to right to profession, occupation, trade and business vis-a-vis, or you can say in conflict with, right to healthy and clean environment. For example, I can refer here in MC Mehta versus Union of India. The Supreme Court held that right to life, it includes right to defend the human environment for the present and future generation. And in this case, the Supreme Court directed certain tanneries at Kanpur to stop functioning as these were discharging foul effluents without setting up a primary treatment plant, and held that we are conscious, the Supreme Court held that we are conscious that the closure of industries may bring unemployment. It may bring loss of revenue, but life and health and ecology have greater importance to the people. The Supreme Court opined thereafter in a number of judgments, like as in introduction of CNG, throwing out of 39,000 units, industrial units out of Delhi. And in these cases, the Honorable Supreme Court held that any trade or business which is offensive to ecology cannot be carried on in the name of fundamental right. In fact, whenever there is conflict between the social interest and individual interest, the societal interest would prevail. And recently, in T.N. Godavaraman Thirumulpad versus Union of India, in 2007, the Supreme Court allowed the fishermen to carry on their job of fishing by traditional method. without causing environmental hazard. It further allowed the agriculturists to do traditional agriculture without using pesticides and chemicals. Similarly, following the same principle, the Uttaranchal High Court in Muhammad Haji Rafiq versus State of Uttaranchal justified the rules enshrined under the Forest Act and Uttaranchal Establishment and Regulation of Sawmill Rules Act 2004, by which the opening of sawmills was prohibited to preserve and protect forest and prevent illicit felling of trees and destruction of forest. So this is the way in which the Supreme Court resolved the conflict between the right to profession versus right to clean and healthy environment. And thereafter comes right to freedom of religion. Right to freedom of religion in quandary with right to protection against noise pollution. There are two leading cases on this problem. First is P.A. Jacob versus the Superintendent of Police, where the Kerala High Court made it clear that the freedom of speech, freedom of religion, both of them does not include freedom to use loudspeakers.
Gospel church.
And or to use sound amplifiers to cause noise pollution and risk to human health. The court made it very clear that the operation of mechanical sound devices conflicts with the quiet enjoyment of man at park and at his home. So, further, while the petitioner has right to express his view, but he has no right to force his message upon an audience declining to receive it. And the Supreme Court further made it clear that the Constitution has given religious institutions fundamental right to practice, profess and propagate their religion, their faith in religion. But it does not include the right to add noise pollution on the or under the wheel of religion. So whether beating of drums or reciting of prayers by use of microphones and loudspeakers so as to disturb the peace and order of neighborhood should be permitted under the name of religion. So this is what the Supreme Court stated, and in re-noise pollution case, there are 6 judgments in the year of 2005. Those were pronounced by His Lordship Justice R.C. Lahoti. The Supreme Court replied it by holding the negative view towards absolute religious freedom, because democracy implies absence of absolute freedoms. Absolute freedoms or rights cannot be granted in a civilized society. So the Supreme Court held that undisputedly no religion prescribes that prayers should be performed by disturbing the peace of others, or nor does it preach that they should be through voice amplifiers or beating of drums. In our view, in a civilized society, in the name of religion, activities which disturb old, infirm persons, students or children having their sleep in the early hours or during daytime, or other persons carrying on other activities cannot be permitted in the name of religion. So the use of loudspeaker cannot be must for performing any religious act. So through these judgments we can make an analysis that the Supreme Court has tried its endeavor, has performed its endeavor in a preeminent manner to strike the balance among the conflictual interests in the society. And thereafter, right to information has also been recognized in the cases of environment protection. And now I am coming towards the point of environmental justice. Environmental justice through organizing principles. These there are some fundamental principles, organizing principles of international environmental law. The Supreme Court has also adopted those principles and declared them as a part of our land, like intergenerational equity, sustainable development, precautionary principle, and polluter pays. So regarding doctrine of intergenerational equity, I would like to quote the judgment of the Apex Court in Bombay Dyeing and Manufacturing Company Limited versus Bombay Environmental Action Group, pronounced in 2006, where the Supreme Court held it is not possible to ignore intergenerational interest as well as the need of development. So keeping in view the needs of forthcoming generation, the posterity, the court has